Because the Supreme Court is not choosing to weigh in quickly, Trump's team will now argue its case before a 3-judge panel on the Federal Appeals Court. Oral arguments in that appeal begin January 9th. If those judges rule against Trump, he can still appeal to the full D.C. Appeals Court, what is known as an en banc ruling. And if he loses again with the full court, he can take up the issue with the Supreme Court again. What that all means for the trial's scheduled March 4th start date is anyone's guess. Joining me now is Josh Gerstein, senior legal affairs reporter at Politico, and Joyce Vance, former U.S. attorney in the Northern District of Alabama and now an MSNBC legal analyst. Josh and Joyce, thank you for joining me. Joyce, I'm eager to hear your sort of thoughts and analysis about the Supreme Court decision and just how problematic it is potentially for that March 4th start date.
Yeah, I mean, I think that's the question, Alex, and it's very hard to give a meaningful answer because there are so many moving parts and so many variables. This could just be a blip on the radar screen. It's possible, and Jack Smith asked the Supreme Court to be prepared to take this case immediately after the Court of Appeals decides it. So in an optimistic view, the Court of Appeals could move quickly, the Supreme Court could jump right in, and there could be a fast decision. But that's far from assured. And there's a much, I think, for people who would like to see this case tried before the election, there's a much darker path where the Court of Appeals takes a little bit more time. Trump expends the 45 days that he gets to ask for the rehearing en banc that you just asked for. He then gets 90 days to apply to the Supreme Court for certiorari. And there's no guarantee that they would move fast. They could move slowly. We could be theoretically looking at a situation where they don't decide the case until late June or early July. And we just don't know how this will go or if there's some in-between path. But the one sort of ray of hope that I see in today's decision, we don't know what the court's thinking is. It's just one sentence. But there are no recorded dissents. And if there was some feeling of doom on the court that Donald Trump was going to escape responsibility at the hands of the Supreme Court, I think we would have seen dissents from some of the liberal justices. And the fact that we didn't see those today gives me just a wee bit of hope.
Josh, I know there's been a lot of speculation about how the court is going to rule on any number of items that are issues that appear on its horizon, whether it's the 14th Amendment appeal that is coming as a result of the Colorado State Supreme Court, or the question of obstruction of justice that's coming from one of the January 6 defendants that in turn may affect some of the same charges that Donald Trump is facing. Do you think I know I'm asking you to read tea leaves here, but do you think that there's any sort of effect that this decision will have on those other decisions that the court could take up?
Well, I think it's very rare, Alex, for the court or the justices to acknowledge any interplay like that. But we do know that sometimes that does happen in cases. I think back to the Obamacare case where it looked like some votes might have been traded there on two different aspects of that case. And so I could see a situation here, and I think a lot of legal analysts have said that this is possible, where the Supreme Court ultimately does allow some trial of former President Trump to go forward, a criminal trial, but, puts other issues like this 14th Amendment issue, which to many people I think is potentially more explosive, the notion of knocking Trump off the ballot in a lot of different states, maybe doesn't allow that to happen, but does allow the trials to occur. So it's hard to know what's going on behind the scenes, except as Joyce says, there may be other reasons. If there was consensus on this at the court, we don't know if it was 5-4 or 9-0. But, they have been discussing, Alex, you showed that graphic a couple of times of all those decisions in the last few years where they agreed to accelerate cases. There's been a lot of dissension about that issue. And so perhaps this is one camp in that debate sending a signal to another camp in that debate. And hard as it may be to believe, it's not totally about Trump in this particular instance.
It's just about factionalism on the court. Reassuring, not really. Joyce, all eyes now turn to the D.C. Circuit Court of Appeals, right? That court has been handling this case and this iteration of this case fairly expeditiously. Oral arguments start January 9th. But I think it took them 20 months to decide the presidential immunity defense in the civil case against Trump. Do you have any reason to believe, A, that it's going to take that long, or B, that they'll permit this stay to remain in place, which is effectively frozen all of the pretrial movement that is kind of necessary to keep the trains on the tracks?
Right. So we have to understand what this motion is to take a look at those questions, because the motion to dismiss that Trump filed on the basis of presidential immunity is a dispositive motion. In other words, if he wins, the indictment is dismissed and this case is over. That's what sets this motion aside from other motions that Judge Chutkan has before her. And it's why that stay was issued in the first place, because there's a feeling that when you have a dispositive motion like this, where you've got a right to take an appeal in advance of trial, that you shouldn't have to have any additional litigation burden while that appeal is underway. You know, could the Court of Appeals remove the stay? They might decide that Trump's argument is so very weak here that no further stay is warranted, and they could theoretically do that, forcing him to ask the Supreme Court to reinstate it. So that's one aspect of the problem. The timing issue is, I think, a very interesting one here, because you'll recall, Alex, we had this conversation about how slow it appeared that the Court of Appeals intended to move. Originally, they didn't ask Trump to even complete docketing, just the formal paperwork filing he needed to set this appeal in motion until the end of December. Then Jack Smith asked them to expedite, and they really did hop to. This was a fast briefing schedule. They will hear oral argument on January 9. They've permitted each side 1 hour for argument, so that hearing should be over that morning, and then it should be ready for a decision from the panel. And I think we have every reason to believe that they will act quickly. You know, does that mean 11th Circuit quickly? In the Mark Meadows appeal, the 11th Circuit issued their opinion on the first business day, the Monday following the Friday argument. Maybe they've set a standard that the D.C. Circuit will feel like it has to follow.
What is that? I mean, no matter what has happened, Judge Chutkan is losing weeks here as the stay for as long as the stay remains in place. Even if it's lifted, if the D.C. Circuit Court of Appeals finds for Jack Smith, let's say in the third week of January, that's still a loss of several weeks, Josh. And I wonder how you think that factors into anybody's ability to get a jury selected, to get through all the pretrial motions in time for a March 4th date.
Well, I mean, I think realistically, the March 4th date is already in a lot of trouble. I mean, the jurors, as I understand it, were supposed to come in and fill out their questionnaires, the potential jurors on February 9th. There's obviously back and forth that has to take place even before that occurs. And so it's hard to see, even if somehow this popped out of the Court of Appeals immediately, there were no other stays decided, and you know, everything was back in gear by, say, the 15th or 20th of January. I still think there are a lot of problems getting that case ready for March 4th. The bigger problem right now is that if the case slips by more than a few weeks, it starts to run into the other criminal trial that we haven't mentioned yet that President Trump is facing down in Florida on the classified information issue in Fort Pierce, Florida. And so, you know, that's set for May 20th, and one trial just can't overlap with another one. And so there is an issue already with that March 4th trial date. I think what the Supreme Court did today probably, you know, puts another nail in the coffin of that date. But, you know, can things happen a couple weeks after that? I think it's still a possibility if things move along quickly.
Can we talk about Mar-a-Lago? Because there has been some development on that front, Joyce. Jack Smith was requesting a jury questionnaire go out on February 1st. Judge Aileen Cannon, who has thus far made decisions that I think Trump would not necessarily be upset about, has suggested that questionnaire not go out till the end of February. These are incremental movements, but they feel meaningful, Joyce. Am I wrong to read intent into all of this as far as pushing this trial date further and further down the line?
Yes, so I think Jack Smith was, this is a technical legal term, poking the tiger a little bit here to see what would happen if he tried to get the judge to take steps towards commencing trial. I think he's frankly testing the waters to see if she's serious about taking the case to trial or not. There's reason to believe she isn't, from the way she's been handling some of the classified information rulings and not stacking things up in time. And if, for instance, she's not serious about her May trial date, that might leave room for a trial in Fulton County, Georgia in that period of time. So you asked earlier about whether judges, I think you were referencing the Supreme Court, look at other cases. Here, I think there are a lot of judges looking to other jurisdictions and trying to figure out who will be in a position to go first. It may well end up being the criminal case in Manhattan that's set for late March.
Wow, wouldn't that be ironic? It was the first one in terms of the criminal cases, and it may be the first one to go to trial. We will see a lot of unknowns. Josh Gerstein, Joyce Vance, thank you both so much for your time tonight.
Thank you.